If there is one message, is that international law isn't a specialist domain sitting apart from diplomacy. It is diplomacy's keystone. And understanding it, even at the practical level, makes diplomats more effective in advancing their country's interests and more capable of reinforcing the rule of law at the international level, which right now needs all the reinforcement it can get.
Hello and welcome. You're listening to The Next Page, the podcast of the Library and Archives dedicated to knowledge and research on the evolution and new frontiers of multilateralism. And in this episode, we are delighted and honored to welcome Mario Oyarzábal. He is the legal advisor to the Argentine Ministry of Foreign Affairs. He is a member of the United Nations International Law Commission, and he has just edited a new book called International Law for Diplomats, which is why he's here today to talk about it. Welcome, Mario.
Thank you very much. It's a great pleasure to be here. I'm very grateful to the library for this opportunity to speak about the book, which is not of my authorship, but with other more than 20 authors who speak about different important fields of international law in general, but also in the current context.
Oh, well, we'll hear a bit more about the current context soon, I hope. But tell us more about the book. I noted that it sets out to offer a very practical perspective on international law. Is this was something that was missing? Was there a gap there, did you find?
Yes, to my knowledge, there is no book with the same object and the same angle, the same authorship. A number of books have been written with diplomats in mind, but they tend to focus more narrowly on diplomatic privileges and immunities. And there is, of course, an enormous scholarship literature on international law and diplomacy, but it is written for lawyers, by lawyers, and an academic register. What was missing, in my view, was something written by practitioners, for practitioners. A single volume that walks a diplomat, lawyers or not, through the areas of international law that they are actually likely to run into their professional life. And that would be from treaty negotiations to state immunity to the use of force in a language that doesn't assume a law degree.
Right. So it was really important for you to have both these two perspectives, both for lawyers and for non-lawyers. Yeah.
Yeah, and for me, it was important to address both because that's who actually sit at the negotiation table in ministries of foreign affairs and in delegations to international organizations. There are career diplomats with a legal background, and there are career diplomats without a legal background, working side by side. If a book only speaks to lawyers, then it misses most of its natural audience. And that's why I asked every contributor to write clearly and to the point in a language that was accessible to non-lawyers with a light touch on bibliographical or jurisprudential references, and to leave out whatever might be academically interesting, but it's of no real use for a diplomat in practice. The purpose is to give every diplomat, career or non-career, lawyer or not, the basic tools to handle the international legal issues that come up in the international agenda.
Very interesting. It must have been quite a challenge to get the contributing authors to write in this style that you're proposing when it's something that they're not used to. But you also, or the book says that not only does it give this practical perspective, but it deliberately avoids delving into these abstract theoretical discussions, which I know lawyers are well used to and very at home in. Could you give us a concrete example from the book of a topic where you deliberately chose this practicality over theory?
Oh, indeed. I think the clearest example is the invalidity of treaties. It's a topic that generates a great deal of academic debate. Grounds for invalidity, the interplay with jus cogens, procedural questions under the Vienna Convention on the Law of Treaties. But it's rarely, if ever, something a diplomat actually has to argue or apply in practice. So rather than giving it the theoretical treatment of a treaty's work, we chose to keep the book's attention on the issues that actually diplomats encounter in practice, like negotiating a treaty, understanding an immunity claim, framing a state's position in a dispute. That's really the editorial principle across the whole book to state the law and the general trends as objectively as possible, but don't chase erudition for its own sake.
And so on that particular topic, give us the little new thing that you're suggesting for diplomats in their way to understand it. Is it possible to sum that up a bit on the invalidity of treaties? It would be too long.
Yeah.
It would be too long.
We will be dealing with something very specific
Okay.
that precisely we are trying to avoid.
Here, right.
But that doesn't mean that the topic is not extremely relevant, including in some case law and some relevant examples these days. But perhaps it goes into something extremely specific, and that it will not be something that even a legal advisor behind the desk at the foreign ministry will be dealing with normally.
I see. It sounded so interesting. You cover so much in this book. There are 22 chapters, and you're looking, as you mentioned, at treaty negotiations, human rights, humanitarian law, disarmament, environmental law, dispute settlement. How did you decide on this structure, and what were the key pillars you felt every diplomat really needed to understand?
Well, I grouped the materials around three kinds of issues. First, the systemic ones, the architecture, the states and international organizations, the United Nations law, the law of the sea. Second, the current issues, the questions that are live in today's diplomatic practice, like immunities of states and state officials, the threat of use of force, international humanitarian law. And the third, the practical ones, the craft of diplomacy itself, how multilateral treaties are actually negotiated and how disputes get settled. Within the frame, the 22 chapters move from the sources and the nature of international law through treaty making and international organizations to specific regimes, diplomatic and consular law, state responsibility, the law of the sea, the Arctic and the Antarctic, disarmaments, human rights, humanitarian law, international criminal responsibility, environmental law, international economic law, dispute settlement before the ICJ, the use of force and counterterrorism. Each of these pillars are, to my view, likely to appear and to be of need for diplomats in their professional practice.
So, despite covering so many topics, it really does have quite a neat and tight framework to it. I wondered whether you would just say a bit more about what were the challenges in making this a very coherent volume and not just a collection of all these different topics. But you've given you a 3-part framework for it. But also I wanted to ask, there's a great diversity amongst the contributors to the book, and I wondered what you hope that diversity would also bring.
Before responding to your question, I would also mention that despite the large number of topics that the book deals with, it's a fairly small book. And that was also something that we aimed at, that we provide a book that can be consulted by diplomats more or less quick, so they can have an overview of all these areas without implying that, or without asking them to delve into like very specific issues, which perhaps may be necessary, but there are ample literature which can be consulted on the basis or after getting to understand some basic rules and principles that are applicable in the respective field of international law. But going now to your question, so I would say first that every contributor is or was a legal advisor to their own foreign ministry. So they share the practitioner's vantage point, which gives the book, I think, a natural coherence even before any editing happens. To reinforce it, I asked everyone to write to a common brief. As I said before, short papers, clear language, a practical focus, minimum footnoting, and each of the contributions, each of the chapters were circulated among the other contributors for them to comment. And precisely that was done in order to catch gaps and contradictions across chapters as far as possible. As for the diversity, the authors come from every region and legal culture, including legal advisors connected to the permanent members of the Security Council, alongside legal advisors to international organizations. And that matters because international law isn't practiced identically everywhere. Having that geographic and institutional range means that a diplomat from any region can find the perspective that speaks to their own context. And the book as a whole better reflects how international law is actually applied across the world rather than a single vantage point.
Interesting. Yeah, and the application of it. The foreword is also by the UN Legal Counsel, Eleanor Hammarskjöld. What role did you envisage for that in sort of framing the message of the book?
Well, first of all, I'm extremely honored, and so are the other authors, for having the UN Legal Counsel having provided the foreword of the book. I wanted the book to open with a reminder from the very office responsible for the United Nations' own legal affairs of why international law matters right now. The foreword situates the book against the Pact of the Future, adopted at the 2024 UN Summit of the Future, where world leaders reaffirmed their commitment to the UN Charter at a moment when international law faces mounting challenges, both in principle and in practice. It also strikes the note, I hope, would run through the whole volume, that international law is a toolbox for cooperation, for resolving disputes peacefully, for accountability. And the diplomats are the ones who carry both the obligation and the possibilities for that toolbox represents. Coming from the UN Legal Counsel, that framing carries, I think, a weight and the legitimacy I couldn't have written or given it myself.
Yes, so let's delve a little bit more into the themes of the book and get onto these very practical ideas. There are several chapters on human rights law and international humanitarian law. And in these sort of contexts where diplomats are very much under pressure to take positions quickly, how can the book help them with framing legally sound and yet very useful responses?
Mm-hmm. Well, I think that that's exactly the situation the book is designed for. And the chapters on human rights and on international humanitarian law, and the latter one was written by the ICRC's chief legal counsel, aren't written as academic service. They are written by practitioners who have had to advise on these questions and the real-time pressure. In a crisis, a diplomat rarely has the luxury of consulting a treatise. I referred to that even already before. What they need is a fast, reliable grasp on the governing framework and the key legal categories and rules that are at stake, so that the position they are capital stake is both legally defensible and operationally workable. So that's the gap those chapters are meant to fill.
You yourself, you've served on multiple international bodies, the International Court of Justice, the Permanent Court of Arbitration, the ILC, of course, and others. How does the book address the specific legal literacy that diplomats need when working in and with international organizations around the world?
So a good part of a diplomat's working life today happens inside international organizations, negotiating resolutions, sitting on committees, appearing before courts and tribunals. And that requires a distinct kind of legal literacy. How international organizations acquire legal personality and conclude treaties, how UN law operates, and how disputes actually get litigated. The book has dedicated chapters on states and international organizations, on United Nations law, on dispute settlements before the ICJ, and each has been written by people who have lived that work from the inside, as legal advisors, as registry officials, as judges. That's also where, as you said, my own experience fits directly into the book, having served as Deputy Permanent Representative to the UN and litigated for Argentina before ICJ and ITLOS. I can humbly say that I know firsthand how much of a diplomat's effectiveness in Geneva and New York depends on understanding the legal machinery of the institution they are working in, and not just the politics of it.
Right, really interesting. And so, as you've mentioned, you've also been a diplomat, a legal advisor, ambassador yourself, and you're a member of the International Law Commission. I was interested in thinking about how your own understanding of the role of international law in diplomacy has evolved over your career.
Yes, I've had indeed the chance to see international law from almost every angle over the years. As a diplomat since 1997, as the legal advisor to the Argentine Foreign Ministry, and now as a member of the UN International Law Commission. And I think that each of those vantage points changes what you notice. Early on, international law can look like a constraint and like a set of rules bounding what a state can do. But over time, I think, and once you've negotiated treaties and argued cases yourself, you start to see it much more as an Argentine diplomat put it, as the keystone of diplomacy, not a limit on diplomacy, but rather the framework that makes diplomacy possible at all. And one of the most effective tools a state has for achieving its own interests.
Yeah, so it eliminates the perimeters, and in some ways, although you experience it at first like a constraint, it actually gives the freedom to practice.
Indeed.
Yeah.
Indeed. And it's important that states understand that as such, particularly smaller states like my own, maybe not small in terms of territory, but states in terms of other power elements.
Very interesting. Yes. You had the book launch here through and with the Library and Archives, and we were delighted to welcome you all for that. I noted that in the description of the book launch, there was mention of the mounting challenges that international law faces, both the practice of and the principles. And you've mentioned also the foreword to the book along these lines. What are the challenges that concern you the most? And how does the book also help diplomats respond?
Mm-hmm. So we are indeed at the moment where serious violations of international law are evident in ongoing conflicts, even as states have just reaffirmed, as I said before, in the Pact of the Future, their commitment to the UN Charter and to resolving disputes peacefully rather than through the threat or use of force. The gap between commitment and compliance is concerning, as it is the seeming distrust by many in the international institutions underpinning international law, which I would say that is what concerns me the most. At the same time, there is a real momentum on the development side. The United Nations is moving towards new treaties on the protection of persons in disasters and on crimes against humanity, and the BBNJ agreement on marine biodiversity beyond national jurisdictions has recently entered into force. Diplomats need to be equipped for both realities at once. They should be able to invoke and defend the law when it's under strain. They should be able to participate meaningfully in negotiating its next generation of rules. That dual competence, I think, is what the book tries to build.
Yes. So how then would you like the book to be used and practiced in this dual purpose that it has?
So I'd like the book to sit on a diplomat's desk as a reference material, something to reach for before a negotiation, before drafting instructions, before a difficult meeting, rather than something read once and shelved. It's meant to give diplomats, wherever they serve and whatever their legal background, basic knowledge and tools they can actually use in negotiations and in multilateral fora. If there is one message, is that international law isn't a specialist domain sitting apart from diplomacy. It is diplomacy's keystone. And understanding it, even at the practical level, makes diplomats more effective in advancing their country's interests and more capable of reinforcing the rule of law at the international level, which right now needs all the reinforcement they can get.
What a wonderful way to end. Mario Oyarzábal, thank you so much for joining us today.
No, thank you once again for this opportunity, as well as for the opportunity given to me or to us as collective authors to present the book no less than in the Palais des Nations, which has such meaningful connotations. In terms of I always say international law cannot be understood without the institutions that underpin it. There is no international law without international institutions, and the UN reflects just that.
Fantastic. Thank you so much.